Good morning. Thank you very much for joining us today for the Q4 legal and compliance update for residential block management. Just wait for a moment as the room starts to fill up. For those of you who've been here before, welcome back. For those of you who's the first time, welcome. Over the next hour or so, we're hoping to give you a huge amount of information, insights, and possibly some thought-provoking stuff about what's coming down the track and affecting our sector. The usual disclaimer, please pay attention to this. This is not and must not be construed as legal advice. This is for general information purposes only. Although if you would like specific legal advice on your facts or situation, I'm sure that our guest today will be delighted to assist, and her rates are very reasonable, I'm assured. And her contact details will be available at the end of that. And with that, I'd like, Cass, could you please introduce yourself to anybody who doesn't know you on today's call?
Good morning, everybody. My name's Cassandra Zanelli. I am Solicitor and CEO at Property Management Legal Services, and thank you for having me back for Q4. Thank you.
The feedback has been pretty positive about the stuff we've covered, and we've tried to take comments and insights from the audience into account when devising today's agenda. And so with that, we are starting with a couple of primers, in fact, 3 primers. So these are areas that come up quite often through legal practice or questions that are asked, where a refresher or introduction, depending on where you are in your career in block management, might be useful. We're then going to go into a deep dive around some things that are particularly important for the sector at the moment, including the code on behaviour, things that came up in the budget, where we are on the building safety bill, because we've talked about that a lot. There have been updates, not as many as perhaps we would have anticipated. And then the key sort of deep dive today is on challenges with going green. And there was an announcement today about electrical vehicle, I'm not going to use acronyms, electrical vehicle charging, which I think is going to have a material impact on all block managers. And so with that, into our first primer, so the right of first refusal. There's an increasing number of them at the moment. What should block managers bear in mind when it comes to rights of first refusal? Over to you, Cass.
Thank you. Yeah, as you say, Raj, there are more of these knocking around at the moment than I have historically seen or been used to. And from looking on social media at the various posts on LinkedIn and the like, it seems that it's not just me who's experiencing an increase in lessees being given the right of first refusal. Can't speak. It's never a good sign for a webinar, is it? That mixing up my words to start with. Definitely 11 o'clock in the morning as well. But there seems to be more of these knocking around. So what I thought and what we discussed is it'd be a good idea just to have a very brief run through of what the right of first refusal actually is. I should say, as a bit of a disclaimer at the start, typical lawyer saying this, that it has the ability to become a bit of a minefield for the unwary. So this is a very high-level overview. It's not meant to be an in-depth discussion of right of first refusal. So the right of first refusal is a right that qualifying tenants have under Part 1 of the Landlord and Tenant Act 1987. So we're in the 87 Act here, and it gives residential tenants the right of first refusal, as the name suggests, where a landlord proposes to make certain disposals affecting the whole or part of the premises, so the building. Essentially where the landlord proposes to dispose of their interest in the building or their interest in the premises, then they will be obliged in certain circumstances to give the right of first refusal to the qualifying tenants. So a landlord is prohibited under the 87 Act from making a disposal or from contracting to make a disposal unless they have first given formal offer notices to qualifying tenants and then have made the disposal in accordance with the requirements of sections 6 to 10 of the 87 Act. It's then open to the requisite majority of qualifying tenants to take up that offer, so to take up the landlord's offer, take up the right of first refusal and purchase the landlord's interest in the premises, in their building. If the offer isn't accepted, so leaseholders are under no obligation to accept the offer, and if they accept it, then they can move forward and purchase the landlord's interest in the premises. If they don't accept it, then the landlord can proceed with the proposed disposal to a third party on the same terms as he or she set out in the offer notice. So this isn't like with collective enfranchisements, it's not a forced sale on the part of the landlord. what it is, it's an offer that the landlord is making to sell their interest. It's a take it or leave it offer on the part of the landlord saying that he intends to dispose of his interest and offering the option to the leaseholders, to the qualifying tenants to purchase that interest. So it's reactive on the part of the qualifying tenants rather than being proactive. The majority of disposals that a landlord will make are caught by the right of first refusal, but not all of them are. And as I say, that can be a bit of a complicated area, and there are some exemptions which are way beyond what we've got in our 5-minute introduction today. How it works in practice is the landlord will serve a formal notice on the qualifying tenants, making that offer of first refusal. That's the offer notice that we talk about. It's a criminal offence if the landlord doesn't do that. And there are different types of offer notice depending on how the landlord proposes to dispose of the interest, so whether it's sale by contract, whether it's public auction. Assuming it's a sale on the open market, then the landlord will serve the offer notice. If the tenants or the requisite majority of tenants want to take up that offer, then they serve notice and right to accept that they want to take up the offer. They need 50% or more than 50% of the qualifying tenants, so 1 vote per flat, and they have to serve that acceptance notice within 2 months of the offer notice being received. They then have a period of 2 months to notify the landlord of their nominated person, so the company that they intend to purchase the freehold in the name of. The landlord will then send out a contract within 1 month of that notification, and the contract is then exchanged, returned, signed, and the sale then completes. I've made that sound incredibly easy for the last bit of it. Not quite as easy as that, but that's an overview, a very general overview of the process. As I say, I'm seeing more of these coming through where qualifying tenants are being served with these Section 5 notices. If you do receive one, or if you're a managing agent and you've been told that leaseholders have received one, then I think the message is probably not to dilly-dally. There are deadlines here, and these are deadlines, not targets. And sometimes it takes a little bit of time, doesn't it, to organise people so that they can decide whether or not to participate in that purchase. So if you get one, don't dilly-dally, do something about it, make that decision to see whether or not you do want to accept that right of first refusal that's being offered.
Excellent, thank you. And I guess the other side of this is freeholder clients may not be aware of this, so just don't assume that they know. And I think part of the challenge may be that they wouldn't expect a right of first refusal to apply, because it doesn't typically apply across residential property as a sector by default. And so just be aware and act appropriately and act expeditiously. We're going to go on now to a topic that we've touched on through a number of the case updates we've done over the last year, and it's come up in various guises. So another 5-minute primer on licenses and permissions. And I guess the top question is, what's the difference between an absolute prohibition or a qualified prohibition? And from that, what are the pitfalls about, I guess, things like that sounds okay in practice or in principle? Are you able to sort of give an overview of the legal position, so the difference between absolute and qualified, but also some of the things that you see people perhaps getting wrong in practice that can have consequences?
Absolutely. And this gives me an opportunity. You know, I like an opportunity to jump on my soapbox. This gives me an opportunity to do that. So thank you. And it is jumping on my soapbox and reminding people of the importance of reading, understanding, and implementing the terms of your leases. Because your leases will contain a raft of covenants that a party is required to abide by. And your leases, as we all know, vary from block to block to block. So what is an absolute covenant in one lease might not be an absolute covenant in your next lease. So you need to have understood, you need to have read, understood, and then put into practice and implement what's in your leases. And your leases will contain a variety of absolute covenants, qualified covenants, and fully qualified covenants. So an absolute covenant is, as the name suggests, an absolute bar or prohibition against doing something. I'll give you an example in the context of pets. You must not keep pets, full stop. Absolute prohibition against keeping pets. People at this point always think that I've got something against pets. I've not. I love pets, but it's just a very easy example to give. A qualified covenant is a covenant that requires the landlord or management company's consent, depending on who the beneficiary of that covenant is. So a qualified covenant in relation to pets would say something like not to keep pets without the consent of the landlord. There's then a third tranche of covenants which are fully qualified covenants, and that is a covenant that requires the landlord or management company's consent, but states that that consent must not be unreasonably withheld. So back to my pets example, not to keep pets without the consent of the landlord, such consent not to be unreasonably withheld. So when you're looking at your leases and looking at your leases in the context of permissions or consents or licenses, whatever kind of permission, consent or license you're dealing with, that's what you're looking for in your covenant. Are you dealing with an absolute covenant? Are you dealing with a qualified covenant? Are you dealing with a fully qualified covenant? And you need to know what territory you're in, what kind of covenant territory you're in, because the response that you give to the request that's been made may well be different if you're in qualified covenant territory to absolute covenant territory. And the reason that I say it may well be different is because of the decision of the Supreme Court in the Duval and Randolph Crescent case. It's a case that I'm sure everybody is familiar with because lawyers have talked about it a lot. In the Duval case, there was an absolute prohibition in the leases against cutting, maiming, and injuring wolves. I always feel very sorry for wolves at that point. I think that they've been maimed or injured. And in Duval, the landlord gave permission to a leaseholder to knock down, it was about 8 meters of load-bearing wall. The landlord therefore gave permission for something that would otherwise have been a breach of an absolute prohibition because there was an absolute prohibition against cutting, maiming, injuring. And the landlord in the Duval leases, as in most leases, I have to say, had covenanted that all leases would be in similar form and contain similar covenants. So in other words, that all leases would prohibit the maiming and injuring of wolves. The landlord has also covenanted in Duval, again, as is common with most other leases, that they would take action in the event of a breach of covenant on the part of a leaseholder. And what happened in Duval, to cut a very long story very short, is that the Supreme Court found that the landlord had breached the terms of the lease. So it's a landlord that's committing the breach of the lease in Duval, and that they breached their covenants because the landlord had licensed something that would otherwise have been absolutely prohibited. Now, although Duval is about alterations, so knocking down that 8 meters of load-bearing wall, it does have much wider implications about any kind of consents or permissions or licenses. So pets, subletting, wooden floors, a whole range of things that are prohibited or the lessees have covenanted to do are caught by Duval, which is why I say it's so important to understand what kind of covenant territory you're in, whether you're in absolute, whether you're in qualified. And so you know then how to react to that request that's been made for permission to have a pet, for permission to lay wooden flooring instead of carpets. And you know then whether to give permission for that or not, and what action you perhaps should take, particularly if you're in absolute covenant territory, before giving that permission. Go into it with your eyes wide open, having read the lease and having understood the risks that you are facing, particularly risks of challenge from other lessees, particularly if you are in absolute covenant territory. That's the danger territory.
Thank you. And just a very quick, I guess, your health warning on what managing agents on today's call should do if they're asked for consent where it's a qualified covenant, in terms of wording like that sounds good in principle or anything like that. So is there anything you'd like to say about the risk of giving consent without actually intending to give consent?
I get on my soapbox about fag packet licenses and fag packet consents, where things are, I'm old, so I remember them being on the back of fag packets, but in a rather rustic fashion. I think it's much better for purposes of clarity if agreements are consigned to writing and they are in the form of a formal agreement, so that parties know what's been agreed and what's not been agreed, and then they can also build in any indemnities and the like in relation to that as well. For something that's simple, you would have a much shorter form agreement. For something that's a wholesale alterations to a flat, then you would have obviously much longer agreement, and you'd probably have involvement of other professionals such as surveyors as well.
And it's beneficial to have things properly documented, not just for the managing agent, freeholder clients, but also for the lessee themselves, because when they come to sell the property or to mortgage or remortgage or whatever they're doing in terms of transactions, people will need to know that things have been appropriately documented. Otherwise, they may be going back to get retrospective appropriate licenses, and that slows transactions, risks transactions, and costs money.
Absolutely. And if people are interested in when to give consent, when to not give consent if we're in qualified covenant territory, there's a case from a couple of years ago now, all about Vinny the dog. It's the Victory Place and Cohen case, and if you Google it, you'll be able to find it. I love that case because Vinny was such a cute dog.
Thank you, Cass. And with that, we're going to move on to our third and final primer topic. Hopefully, so we've taken the feedback from previous webinars, and these sorts of primers have been things that people have asked for. But again, please tell us. So through the Q&A button, if you've got any questions on what's been discussed, any comments, insights, or any feedback about whether this is too much detail or not enough detail, please put it into the Q&A. We are here to serve you. This is supposed to deliver value to you, the audience. And so the next quick primer is dispensation. So what is dispensation? When might it be appropriate to make an application to the tribunal for dispensation?
Thank you. I've seen an increase in the number of dispensation applications that are knocking around at the moment, if you'll forgive my colloquial. Section 20 is one of the statutory restrictions on the recovery of service charges. It covers qualifying works, so works to a building or other premises, and covers qualifying long-term agreements. And Section 20 says that unless you undertake a consultation exercise, so for those in England in accordance with the 2003 regs, those in Wales in accordance with the 2004 regs, unless you undertake that consultation exercise or go to the tribunal and get dispensation, then for qualifying works, you're capped at 250 quid per lessee. For a qualifying long-term agreement, you're capped at £100 per lessee per financial period. And the tribunal, so the FTT in England, LVT in Wales, hold jurisdiction to dispense with some or all of the consultation requirements if they consider it just and reasonable to do so. And that's set down by Section 20ZA of the 85 Act. I see applications in two broad scenarios. So either an application for dispensation before the works or the QLTA have been entered into, so before the works are carried out or before the agreement entered into. I also see applications for dispensation after the event. So your application can be made before you break ground or spend a penny of somebody else's money, or after the event, perhaps there's been a fault that's been discovered with the consultation exercise after the event, and it's necessary to go and get dispensation. So the questions for the tribunal when they are dealing with an application for dispensation are, firstly, should dispensation be granted? And we have the Dejon and Benson case from 2013. Again, it's a Supreme Court case. I'm getting old, so I remember Dejon and Benson when it was Court of Appeal before Supreme Court, but that's just my age. So first question for the tribunal, should dispensation be granted? And they'll follow what Dejon and Benson says in relation to that. And if so, on what terms? Because we know from Dejon and Benson that dispensation isn't binary, so it's not either yes or no. It can be yes, subject to certain terms. So common scenarios that I'm seeing in a dispensation world are dispensation where works are needed on an emergency basis. I've seen a lot of that at the moment, particularly in a fire safety context and a building safety context, that we haven't got time to go through the consultation exercise because that's going to take at least a couple of months to do that. We need dispensation on an emergency basis because we need to get the works done. I also see commonly applications for dispensation where there's only one supplier. And you'll know as part of the consultation exercise at stage 1, I intend to do the works. Stage 2, here are the contractors I propose, and here's at least 2 contractors I propose. If you only have one contractor, you can't do your stage 2. So I see quite a number of dispensations on that basis. And there's a growing trend for dispensations for non-eligible works under Building Safety Fund. So Building Safety Fund covers certain works. It doesn't perhaps cover all of the works that might be needed at a building, but perhaps you want the same contractor for efficiency and cost-saving purposes to do the rest of the works that are required. So I'm seeing more applications for dispensation for those non-eligible works. So more and more applications coming through. 2 questions for the tribunal. Should dispensation be granted? If so, on what terms?
Excellent, thank you. And so that covers off the 3 primer topics. We've got some questions that have come in, and we'll come back to all of the audience questions at the end of the final part of the agenda. The next point, I would say, is more because Cass and I discussed this, and we really wanted to signpost the ARMA IRPM policy, but at least anecdotally from speaking with clients, it sounds like, so I've got no empirical evidence, but it sounds like some lessees are becoming more demanding, and that their expectations of what they can expect within their buildings are increasing. And there seems to be a sense of frustration. We're hearing the same from the retail sector and others. So what is the ARMA IRPM unreasonable behaviour policy? And more importantly, for the people on today's call, what does it mean for professionals in the sector? How can they use it? How can they use it to protect their mental health more than anything else? So over to you, Cass.
Absolutely. And I think this comes on the back, doesn't it, of recognising that being a property manager is not an easy profession. I take my hats off to you guys out there that are managing properties. You do a fantastic job. You're managing people's homes. You're keeping them safe in their homes. It's not easy to do what you do, and certainly hasn't been an easy ride for you over the last 18 months, 2 years or so. And what the unreasonable behaviour policy seems to come on the back of is a teaming up, if you will, of ARMA and IRPM to provide a mental health check of residential property management professionals. And they did that by conducting a sector-wide survey to try and understand and try and identify some of the key pressure points that affected professionals. And I'm sure that the links to the survey to be able to download that report will be in the ebook that comes to everybody after this webinar. And what that survey did is that it helped IRPM and ARMA identify certain actions that could be implemented, and highlighted the need for some larger measures that need to be reviewed on a greater scale within our industry. And one of the things that IRPM and ARMA have delivered as a result of that survey is the unreasonable behaviour policy. I've spoken to lots of my clients regarding this, and everybody that I've spoken to without question has welcomed this unreasonable behaviour policy, recognising the real difficult times that they've had over the last 18 months or so. And the policy, if you haven't read it, I really do encourage you to go and have a read of it, and to implement it, adapt it and implement it within your organisations. It outlines some suggested forms of unreasonable behaviour which management agents should be aware of. It also provides some strategies that managing agents might like to adopt in order to protect staff from unreasonable behaviour. So it discusses things such as what unreasonable behaviour is, kind of forms of unreasonable behaviour, so and people being unreasonably persistent, which is a theme I hear about a lot, people being rude, people being angry, people being aggressive, making insulting remarks or inflammatory remarks. It deals with strategies to deal with unreasonable behaviour, so limiting contact, terminating calls, termination of contract in the most extreme cases, and also informing the authorities. So if you haven't taken a look either at the survey itself or at the unreasonable behaviour policy, then I really do encourage you to do so and to look to adapt and implement that within your organisations.
Amazing, thank you. And we've had previous webinars around apprenticeships and getting more people into the sector. Again, anecdotally, I feel that some people may not gravitate towards residential property management for the fear of unreasonable behaviour from people they're dealing with. So reviewing it, implementing it within your business and making it clear within your recruitment policy will hopefully to get more people to be attracted into the residential property management sector. we're going to go through the next couple of topics very quickly because actually, when we were devising the agenda, I think we were expecting much more material impact from them. So the first is from the budget. What are the announcements that came, if you can remember that back that far, in the autumn budget that had the greatest impact on the residential leasehold management sector? What were your key points that people may have missed or you'd just like to underline, Cass?
It seems such a long time ago now, doesn't it?
It does.
It really does. Time is flying. It'll be Christmas before we know it. So at a glance, there was £10 billion for affordable homes programme. There's £6 billion to boost housing supply. There's £3 billion on Help to Buy, and then £3 billion on building safety too. There's the developers levy, or the so-called cladding tax, and there's money being spent on heat pumps as well, so 450 million to go to heat pumps, which is quite interesting, particularly given what's coming up later in this webinar with regards to the challenges of going green. I think it's certainly something that we're all thinking about a lot more these days, isn't it?
It is, and so I'm not going to get the acronym correct. So Department of Leveling Up Community. Hang on. DLUC. Thank you very much. There is at least speculation that Michael Gove, who heads up the department, is reviewing everything around cladding. There's been lots of announcements. So while there wasn't, I guess, enough from my perspective in the budget, I would expect further announcements. I just sort of caution people to differentiate between re-announcements of things that have already been committed and what is actually net new money coming in to fix the problems. I think that's probably an important differentiation.
Cautioning people against politicking.
Well, it feels like that ship has sailed. And again, moving on quickly, because again, we were expecting significant changes, updates, insights for you on the draft building safety bill. There was a new draft since the last webinar, I believe, Cass, but it just doesn't seem to have moved on with the pace or vigor that I would have anticipated. So is there anything that you think the audience needs to know?
We've gone through committee stage now, so that's the development that's happened since last time we spoke, and we're now at report stage. I expect things to move on a little bit now with the building safety bill, so lots of amendments, and we're moving to the ping pong stage as well. So if you remember with Fire Safety Act, we had quite a bit of ping pong between the two houses, and I suspect that we're going to have a similar amount, if not more, in relation to the building safety bill. So please do keep up to date with what's happening with that and follow the amendments and as the bill is progressing.
Excellent, thank you. And now, and hopefully of interest to everyone in the audience, this is our deep dive section. So the challenges with going green. There has been a lot in the press and specifically today, which I think keeps us on our toes, Cass, in terms of keeping everything up to date. But if we could start with EPCs. So I guess even stepping back, COP26 has completed. There were not quite as many firm commitments as people expected, but the general direction is towards net zero across the world. Now, query whether net zero is the right metric or whether it can be gained, but that is the direction of travel. And there's a recognition that buildings, both residential and commercial, are sources of large amounts of carbon, both through the development and then through operation and then through redevelopment. So net zero is going to impact the residential property sector immensely and increasingly over time. One of the tools that's currently in place is the EPC. So what can leaseholders expect when it comes to energy efficiency policies? Would they be required to raise their EPC ratings to sell or lease their property in the coming years? And before we get the comment saying that affects letting agents and not managing agents, or estate agents not managing agents, why does this matter to the audience?
Absolutely. I think there are some big changes that are coming in relation to the energy efficiency of homes that are rented, that are mortgaged and that are sold. It's going to affect us all in relation to that. There is a bit of background to this because we have since 2008 the requirement for property that's let on an assured short hold tenancy to have an EPC, so an energy performance certificate. And then in 2020, we have the minimum energy efficiency standards that are introduced, so MEES. that are introduced, and they required landlords to make changes to properties that had a rating of F to G or F and G. So EPC energy performance certificates use a rating system. So you have rating from A down to G. And what they do is that they summarize the energy efficiency of the property and provide some recommendations as to how the performance and the rating could be improved. So when the Mises came in 2020, you then have a requirement, if you have a rating of F or G, to make some changes to the property to increase the energy efficiency of the property. We now have a bill that's progressing through the House of Lords, and that's the Minimum Energy Performance of Buildings Bill. Whoever designs the names for these things, I don't know, but that's the name of the bill that's making its progression at the moment. And that's going to require all new tenancies to have an EPC Band C by 31st December 2025 and all existing tenancies by 31st December 2028. And I know that 2025 and 2028 seem an awful long way off at the moment, but they're going to be on us before we know it. So it really is important to have in mind the changes that are coming down the track. And I know that there's lots of changes coming down the track for all sorts of things, but this energy performance and EPC rating is something that agents are going to have to consider because it is coming if the bill goes through as expected. So that all new tenancies to have Band C by 31st December 2025, existing Band C by 31st December 2028. Watch this space for developments on that.
So thank you. I find it interesting that thus far, at least, unless things have changed very recently, buy-to-let lenders haven't really focused that much on the ability to rent a property into the future based on the current EPC ratings, but I suspect that will come up, and with the spectre of increasing interest rates, perhaps people looking to remortgage, I feel like it's all going to come together at a single point and be a bit of a challenge. And now,
because we now have green mortgages as well, don't we? We're starting to get that introduced. So lenders being green in the terms that they're granting their mortgages on.
And now into something that changed only as of this morning, I believe it was. So electric vehicle charging. Hopefully, people are aware electric vehicles are going to make up a greater proportion of the cars and other vehicles across the UK over time. We've seen lots of policy changes, like the ultra low emission zone across London, extending down to the South Circular, things like that. I find this absolutely fascinating because I'm a horrible geek, but for residential block management, there are so many different strands at play. Cass, what should block managers be thinking about? And then we can go into, I guess, a discussion about what today's announcement actually means, because it doesn't seem to deal with many or any of the strands that we're about to discuss.
No, absolutely. It deals with the new stock, but doesn't really deal with the 4.3 million leasehold that we have as existing second-hand stock. And I'm same as you, Raj. I think this is a really interesting area. I'm not down in London. I'm up north. I'm Game of Thrones. I'm up beyond the wall. But even I've got an electric vehicle now. So this is something that I have a particular personal interest in. I've ditched my diesel car and gone for fully electric, and it's amazing. If you haven't got an electric vehicle yet, I commend it to you. They are ace. Are you electric yet?
We've got an electric vehicle on order, but it has been delayed for approximately 12 months so far. Eventually it'll arrive.
They are amazing. Really are. Sorry, I'll stop my sales speech now.
If we go right back to the beginning and say, what are the key issues for managing agents when they are considering installing electrical vehicle charging in an existing building? And then I guess we can come on to what today's announcement actually means.
The key issue is the lease. The key issue and the key problem, I suppose, is the lease. Because for a second-hand, and I don't mean that disparagingly, but for a block of flats that's already in existence, the position in relation to EV and the installation of charging points is going to be governed by the terms of those residential leases. And the kind of permissions you need and the kind of interests and consents and licenses and agreements are going to depend on what the terms of those individual leases say. So it's back to our mantra of reading, understanding, and implementing the terms of leases. So the first thing that people are going to be looking at is who does that specific parking space where somebody wants to install an EV charging point, who does that belong to? Has it been demised to the leaseholder? Does the leaseholder have an exclusive right to park in that parking space, or is it a parking space that's open to all comers? So first and foremost, where do you want to put this charging point? Who owns or who has rights over where you want to put that charging point? If the space is demised to a leaseholder, so if the leaseholder holds a lease over it, either as a separate lease or as part of their residential flat lease, then it's likely, I think, to be the leaseholder who's going to arrange for the installation of that charging point on their space. If that's the case, then you're probably going to have to get the landlord involved, because you're going to want a way leave from the landlord in relation to the land that's not included within that parking space. So to get the connections, and forgive me, I'm a lawyer, not an electrical engineer, but to get the connection from point A to point B to be able to then utilize that charging point. Your lease is unlikely to place an obligation on the landlord to grant that kind of easement. So this is going to then be a matter for discussion and agreement between the landlord and the leaseholder as to whether the landlord actually gives permission for that way leave, for that easement over the landlord's land. If the leaseholder has a right to use the space, so rather than it being specifically demised under the terms of a lease, then again, arrangements are going to need to be made with the landlord, because that land is retained by the landlord. It doesn't belong to the leaseholder. The leaseholder has a right, and perhaps an exclusive right, to use it. But again, it's a matter of discussion and negotiation between the landlord and the leaseholder as to whether the landlord allows and permits the installation of that charging point. So that deals with the installation of the charging point. But installation is only part of the story. You then have, well, who maintains this? Who ensures this? What happens if the leaseholder who wanted the charging point sells? They move on. Leasehold properties sell on a frequent basis. Your landlord's going to have to think about what the insurance position is. Who's got the insurable interest in relation to this charging point? Who's got the maintenance obligations in relation to this charging point? Is the supply within the block actually suitable for the installation of this kind of charging point anyway? Is it suitable for one? Because it might only be one that's being asked for at the moment. But what if 10 other people decide that EV is a really slick car and that they want an EV as well? How do we then go about installing 10 more charging points? And will the supply that currently feeds the building, will that deal with that? Will it be able to satisfy it? How are you going to manage those future requests? And as I say, what's going to happen when that leaseholder decides that they don't want to live in that flat anymore and want to move down the road, or decide to sell or rent? So it's all of those things that need to be thought about. I think you hear about it, don't you, Raj, on the news about government giving grants for EV charging points, which is absolutely to be commended. What it doesn't deal with, though, is the intricacies and the challenges of residential leasehold and residential leasehold management. That's the problem.
Well, you've touched there on the ability to install and perhaps to maintain, but then you've got the sort of the issues or questions that flow from that. So let's go down. Let's just imagine there is one vehicle charging point in a common car park. Who has the rights to use it?
Is it open to all comers?
Is it open to all comers, or is it pre-allocated or booked? What are the costs associated, and how are they charged back? It's really interesting, and my suspicion is that for managing agents in today's call, this will largely come about from, perhaps not now, but in the not too distant future, people looking to sell their flats, so your current leaseholders, and the acquirer is saying, we would like it if it had electrical vehicle charging, and if not, then it wouldn't work. And you'll be asked, well, can you install it? Can you put it through the service charge? How does this work? And I guess to the point you made, yes, it's absolutely commendable that the government has indicated funds will be available. And if you've not seen today's announcement, please look at it. It's really interesting. But one of the points there was that if there are major works going on at a building, then there will be an obligation to install EV charging by virtue of that. Does that include cladding remediation? There is
what
no
does that actually mean? When is that requirement triggered? How is that requirement triggered? And it's not just about how the requirement is triggered, but it's then the ongoing management and maintenance of that. Can the costs associated with the installation of those 10 charging points, can they be put back through the service charges for the ongoing maintenance and repair of them? What about reselling the electricity? I mean, how is that going to work in practice? I think if anybody watching this today is dealing with these issues, then I'd be really interested to know how you're managing them and how you've managed the process to date.
What happens if the insurance premium for the building shifts because there is a greater perceived risk around it? It'll be interesting. I sort of caution the audience both to, or encourage the audience to get familiar with the issues, but also to keep a watching brief over it, because it is entirely possible that the government will put in some overarching legislation, as they did for telecoms or similar, where it sort of oversteps some of the legal requirements, because this is seen to be for the public good or for policy reasons. But
what I find a bit frustrating at the moment, though, about the government's stance is that they don't seem to be doing that. We had the consultation, didn't we, back in 2019, where they, Department of Transport said that they're going to look at introducing requirements for the installation of EV charge points in new buildings in England. And there were responses saying, well, that's all well and good looking at new buildings, so the new stock, but what about the second-hand stock? So this has been an issue that's been floating around for a couple of years. And what we had yesterday was the response that was published from DfT in relation to that consultation and the responses that they got. And the response talks about the government implementing regulations that are going to require new homes with on-site parking to have an EV charge point. Amazing. Residential buildings undergoing major renovation, which is what you've been talking about, and that will have over 10 on-site parking spaces after renovation to have at least one charge point for each dwelling, with associated cable routes and all the rest of it. New non-residential buildings with over 10 on-site parking spaces to have at least one charge point. Non-residential undergoing major renovation again to have charge points. But it's all new stuff or stuff undergoing major renovation. It doesn't resolve the elephant in the room problem that we have some leases that haven't thought. I mean, when some of the leases were drafted, EV wasn't even a twinkle in somebody's eye. But the proposals don't seem to deal with that, or those issues that we have with the second-hand stock.
Well, I've got, I guess, a very broad question for you, which hopefully you'll give a very narrow answer to, which is, given that the leasehold construct is in part set up to ensure appropriate use of funds and to prevent frivolous expenditure, and there are lots of constraints around that, what can go through a service charge, what can't. How are managing agents actually going to be able to make the investments needed to support the UK's drive towards net zero? So what can they do when they're sort of looking at any changes with it, making changes with their hands tied behind their back?
It's absolutely right what you say there, because I suspect the argument would go that the installation of charging points is probably an improvement.
Yes.
Does your lease allow for an improvement, or allow for the costs of exercising your discretion to make improvements to be put back through the service charge? There are a whole host of challenges, which is why I say I'd be really, really interested to hear from anybody that has gone through this or is going through this as to how they're coping with those and negotiating those challenges, whether they've thought about them and how they've dealt with the way leave issue, dealt with the license issue, and dealt with the ongoing maintenance issue. I suspect it's working in blocks where you have a small engaged block I wonder how it's working in the bigger blocks with more units.
Excellent. Thank you. I'd quite like to move on to the audience questions, and we've kept to time, astoundingly, and we have a large number of questions. So the first is on the right of first refusal. It's hopefully not too specific, but we'll try and make it as general as possible. What happens when the formal notice relates to 2 buildings, but the leaseholders only wish to purchase the freehold for their building? Let's assume the buildings are under 1 freehold title at the land registry.
Doesn't matter, it's 1 notice that's served per building. So for the purposes of serving the notices, you have a bunch of notices that's served in relation to building 1, and then a separate bunch of notices that's served in relation to building 2.
Excellent, thank you.
What you'd probably get in practice is 1 company that would club together and purchase both buildings rather than splitting the title. But yeah, if 1 block wanted to take up the offer, it doesn't follow that the second block has to.
Amazing. Appointment of directors on. I don't think we covered that today, but we did once upon a time in one of our previous webinars. And if you think the sort of topics we covered today, including the primaries, are of interest, the recordings from previous quarterly updates are available on our website, whether for you or for your colleagues. Please feel free to share them there at fixo.com under the webinar section. So if a member is elected as a director at a directors meeting, does he need to stand down at the next AGM and stand again as a director to be voted on by members of the company?
Depends on your mem and arts. So you need to have a look at your memorandum and articles of association, see what they say in relation to the appointment of directors. You need to make first and foremost that directors can be appointed by board decision, because that's essentially what you've done there, and then have a look at and see what they say in relation to what has to happen with that appointment, whether it has to go for vote at your EGM, AGM.
Excellent, thank you. I'm doing my best to try and keep the questions in the order in which they related to the topic. So we're now on to questions around dispensation. Can lessees waive their right to be consulted under Section 20 by signing an agreement to waive their rights?
Oh, I get asked this all the time. We fixate, don't we, on our only ability to raise money for blocks being to raise money as service charge funds. So we fixate on leases and leasehold management and doing works because the lease tells us to do it, works, and covering the cost of those works via the service charge mechanism. There is more than one way to raise money in relation to a block of flats, potentially. So leasehold and service charges is one of the ways that you do that. And where you rely on your lease and you go for the service charge mechanism, you're caught by Section 20. You're caught by a lot of things, but Section 20 is one of the things that you're caught by. If you want to do works and you have, say, a block of 10 and it's a lessee owned and controlled company, and those 10 lessees are really engaged, then what you could do is that instead of relying on the lease and collecting money as service charges, that you rely on the corporate vehicle and you requisition the lessees in their capacity as members of that company. And because the mem and arts would tell you and would allow you to do that, you're then not caught. If you're using the corporate vehicle, you're not caught by all the Landlord and Tenant Act and Section 20 and all of that shizzle. You are raising the money as a corporate entity from people wearing their member hat, not wearing their lessee hat. So that's your way around consulting under Section 20.
Thank you. And I think that may be the first time I've ever heard a lawyer in spoken or written word use the word shizzle. So I appreciate that. Thank you. I wouldn't use it in formal advice, but moving on. So how long after works are completed can you go for dispensation, and how long after the start of a long-term agreement can you get for dispensation? So
you can go whenever you like. There's nothing in statute that says, certainly nothing in the 85 Act that says you only have a period of 6 months, 12 months to apply for dispensation.
Thank you. I'm just trying to make sure I've understood the next question. So
probably better to go as soon as you're aware that you need to get dispensation.
Yes.
More likely to be able to persuade the tribunal that it is then just and reasonable for them to dispense with the consultation requirements than if you've sat on it for 3 years.
Yes. Sorry, I'm just trying to get the to make a couple of questions that have come in applicable to one question. So if you're applying for dispensation for a long-term agreement, do you need to provide alternatives to that long-term agreement? think
No, because if
that's
you've got alternatives, you probably consult.
yeah. I apologize if I have misunderstood or misconstrued the questions there. If I have, please put them back in. On ARMA IRPM policy, and I suspect this has come in from a service supplier on today's call. So we talked about managing agents leaving the sector or potentially finding it harder to attract people into the sector. Are you seeing anything around service suppliers? Has this flowed through the supply chain? So service suppliers leaving the sector or struggling to recruit or anything like that?
I speak to people out and about, and obviously speak to people as part of my job, as I'm sure that you do as well. And it seems that there is a problem generally that we're having with not being able to recruit and retain staff, certainly in certain sectors of our industry. And I say and use the word industry on a holistic basis. So it does seem to be a problem, a skills shortage problem, and lots of people that I speak to are having the same issues and the same challenges, not necessarily driven by unreasonable behaviour, but just a factor as it is at the moment that there is a bit of a skill shortage and we're struggling to recruit and people are struggling to recruit. But I think there have been people that have left the sector, and organisations that have perhaps left the sector as a result as well.
Again, trying to make the next question still on dispensation as generally applicable as possible. So there was a dispensation application for some works, a replacement of some kit at a building.
Is this asking for a friend?
This is not asking for a friend. There was no consultation. The application for dispensation was submitted to the first tier tribunal. The FTT rejected the application and agreed with the leaseholders objecting. Who then pays for the works that were carried out before? Does it go through an insurance policy? Who pays for works where they were carried out and no consultation was carried out and dispensation has been refused?
I can tell you who doesn't pay for the works, and the parties who don't pay for the works are the leaseholders. They're liable to pay just £250 towards the cost of the works per leaseholder. I appreciate that that may then leave a black hole, and you will need to look to fill that black hole, but that black hole can't be filled by dipping into the service charge pot because you have from the tribunal a refusal of dispensation. That's perhaps when you would look at other alternatives, such as like we've talked about with utilising the corporate vehicle.
Thank you.
Why did you get refused dispensation? That's unusual for a tribunal to refuse dispensation.
I feel like somebody may be calling you, not me, or a friend of mine, but somebody may be calling you after today's webinar, and your contact details will be available in the follow-up notes. In fact, that leads me neatly onto building safety reform. So the question is, when do you expect the fire safety bill to be finalised? We have a Fire Safety Act fact sheet, I have been told, which will go into the follow-up email with all relevant and pertinent information. So it's
there is.
That will be coming out to you.
The Fire Safety Act has been enacted, but there's parts of it that need to come into force, and there's guidance to go around that. It was expected, as people's best guess, that might come out in December or January. So keep watching this space in relation to Fire Safety Act.
A really, I guess, a hard question for you, but you're so diligent, I suspect you'll be fine. The new LPE 1 and 2 and FME 1 were announced yesterday, Cass. Have you had a chance to review them? Do you have any thoughts?
Oh, I'd looked at them before that.
Mm-hmm.
Yes, I have seen them. There have been some changes made to them. Hopefully that will make it a little bit easier for people to understand, or for potential purchasers to understand how they're expected to live and habit a building. So things such as pets and things like that are now taken care of in the new LPE 1. Just standardizes it and makes it a little easier. So it's not just about the money, it's about living in the property as well.
Thank you.
What's people's thoughts in relation to that? Do they like the new LP ones or?
If you have any feedback, so at the end of today's webinar, you'll be asked to provide feedback. If you can leave a comment, if you've had the opportunity to review, it would just be really interesting to know what the sector thinks. I know that I saw Nigel Glenn's comments about this being helpful, both in terms of clarification around pets, but also in terms of fire safety. But please provide feedback to us. We'd love to know what you think. We have a huge number of points around going green, and I'm going to go through some of them relatively quickly. Where can you find today's update on electrical vehicle charging? I think I saw it on the BBC, but I suspect there is an official thing on, did you call them DLUC? So I don't mess up.
It's the Department for Transport, so DFT.
That was it, thank you. A shout out to Jacqueline from ARMA, who's apparently on today's call. So hi, Jacqueline. My understanding is that the new funding around EV charging will be coming in April 22. So thank you very much for that. Most leases provide for the freeholder or leaseholder to comply with statute. So if government dictates net zero improvements to be permitted, would that remove the legal barrier presenting, blocking such work? So, so compliance with law and regulation.
It would be much easier if they introduced a code, you know, like you were talking about with the telecommunications code.
Yeah.
I get the point that somebody's being creative with that clause that talks about compliance with statute, but that will be an interesting litigation in court. You wouldn't necessarily have to have that litigation in court if you had the telecommunications code or something similar to the telecommunications code introduced. You would be
black and white.
ungifting lawyers, absolutely.
It should be absolutely black and white with no area for ambiguity. As soon as you get ambiguity, you get the scope for disputes, breakdown in relationships and costs, although some of those costs make their way to eminent lawyers, so it's not necessarily all bad. But I'd much rather see something that was absolutely crystal clear about what was permitted and why, and how the costs were going to be charged, what happened in terms of insurance and associated rights. And over time, we may even see different types of EV solutions come to the market. So what a future-proofed plan would be wonderful, but obviously we can't drive all of that. And so
it's on our Christmas list.
It is. I am almost out of time, or we're almost out of time today. Cass, this is a very loaded question, and please, if you're still on the call, please listen to this. Is there one thing that you would like to share with the audience before we go? I know there is.
Yes, we have our Oxford Weekender in April 2022. I was about to say 21 then, losing track of years. So over the weekend of the 1st to the 3rd of April 2022, we will be taking over St Hugh's College, Oxford. If you've not been to St Hugh's, it is a fantastic college, amazing. I didn't go there, but it's amazing. There will be about 40 different sessions taking place over the weekend. Starts on Friday afternoon. We stay at St Hugh's in their student digs. We have entertainment on Friday and Saturday night together with dining at St Hugh's, and runs through until Sunday lunchtime. And over the course of the weekend, because we've teamed up with IRPM, you're able to take your level 3 or level 4 exam, taking those exams in written format at St Hugh's. It is fantastic. It's a great weekend, and I'm properly looking forward to it. And I know you're coming along as well.
I cannot wait. It'll be amazing. So please check it out. Everyone who has attended today's webinar will receive a copy of the recording, the follow-up notes and fact sheets, and further information like ebooks, and also information about booking onto the weekend. Please book it because it normally sells out fast, and so please get booking. Just a final request to everybody, and we're working out the plan for next year's webinars. So what do we cover? Which topics are of interest? More primers, fewer primers? Please take a moment at the end of today's webinar, please, and let us know your feedback and thoughts. Be honest, give us a steer, because we do this to help you, and we want to make it as valuable as possible to you. And with that, thank you very much. If you'd like to know about upcoming webinars, follow us on mainly LinkedIn, but all other good social media channels. If you have any feedback you'd like to provide outside of the form, please email us at research@fixlay.com. Cass, thank you so much for sharing your time and expertise, and thank you to everyone in the audience for giving up your time, and hopefully we've been able to add some value, but let us know. And with that, sadly, it is the end of this year's quarterly legal updates for residential block management. We'll be back in the new year with a new agenda driven by your insights. So thank you all very much. Have a great day.
Thank you. Take care, guys.
Bye.